everybody. May I ask you to get closer to us, to sit down, or just to stand outside the curtains if you want to keep talking. Thank you. Okay, I think that we are getting there. Welcome everybody. Thank you for being here with us in this late afternoon academic section, and it's actually a senior academic session. And I feel a little bit my status within CPDP has been upgraded if I'm asked to chair this session. In any case, it's an honor. Thank you very much to the authors for coming here and presenting their paper. I hope that you have prepared a lot of difficult questions, but please don't make them mean. I really believe that we need a different academia, and the different academia starts by how we ask our questions. So I will introduce one after the other. Just maybe one note. I was asked to mention the fact that two of the three papers are going to be presented by seemingly junior scholars. I don't really believe too much in this distinction, but I was asked to make this disclaimer. But in any case, it's an honor to have you here. And the paper were selected for the academic senior academic session because their co-author was a senior academic, the first leading author. So let's start with the first paper and the first presentation by Maria Tzanou. Dr. Maria Tzanou is a senior lecturer in law at Keele University. She holds a PhD from the European University Institute and LLM degrees from Cambridge University, University of Athens, and Bordeaux 4, and the EY. Her research focuses on European constitutional human rights law, privacy, data protection, big data and the Internet of Things, counterterrorism surveillance, and transatlantic data privacy cooperation. She has published her work in journals such as International Data Privacy Law, Human Rights Law Review, Common Market Law Review, Yearbook of European Law and German Law Journal, and her book, The Fundamental Right to Data Protection, Normative Value in the Context of Counterterrorism Surveillance, was published by Hart in 2017. Maria, the floor is yours.
Thank you very much, Rocco. I'm really happy to be here. And I think my presentation, I'll presenting this paper, Mapping AI and Big Data Challenges, What Role for the GDPR, and I think it fits very well with some of the papers we heard in the previous section on digital constitutionalism, in particular Giovanni's and others' papers, so it would be a perfect panel together. I think it ties very well in that. So just a brief clarification on the title. It mentions both AI and big data. Again, it's just pretty much the same. We heard it in previous panels. So I just use an umbrella concept, let's say, to denote big data analytics that includes within that AI. So you might hear me speak about big data or AI. I use them pretty much interchangeably in this presentation, even if I realize that AI is a new trend, while big data is a little bit of what we were talking some years ago. All right, so what I am doing, I will present this paper. What I'm doing in this paper is three main things, basically, and those I will focus on those here as well. First, I develop a taxonomy of big data challenges, and then my main research question is in the light of this taxonomy, or against this background, I try to see the role that the GDPR can play in addressing those big data challenges. And finally, I offer in the end some suggestions as to the way forward. So my taxonomy, in the paper I developed a taxonomy, a classification, let's say, of big data challenges, and I built to do that, I built on the extensive literature and academic scholarship we have already discussing different AI challenges. But what I do is I try to take this a step further, and my, let's say, contribution to the debate is to systematize in a way that literature and I do it with a view to place the GDPR and see the role the GDPR can play in this context. How does my taxonomy look? I basically distinguish and categorize big data challenges at two levels, what I call the individual level and what I call the societal level. What is individual level? I identify there different problems raised by AI and big data that affect somehow the rights, freedoms, and interests of individuals. And then at the societal level, I place there broader consequences of AI that we can see on the whole society. And I don't deny that, in fact, they might affect individuals in different ways. What I say is that it might be difficult to establish the actual harm or harms suffered by individuals. And I think we have to see it as the harms to the collective good, or, let's say, or the society level. And then I distinguish two further dimensions within the individual level challenges. I distinguish between those that they relate to the processing of personal data, and then to those that individual level challenges that I call them relate to the outcomes of the processing. And what do you mean by outcomes of the processing of personal data? I mean all those outputs that we have from data processes. So all of those inferences and conclusions that we draw from algorithmic decision making and all the decisions that are taken as a result of those. The taxonomy, that's how it looks like. What it aims to do is to capture the most important big data issues and AI issues, pulling them together in broader themes. And as I said, I classify them in two levels and further two dimensions when we talk about the individual level challenges. I'm not going to go into detail into each one of those broader themes or challenges. I do analyze them in detail in my paper. I'm happy to circulate that. I'm happy to discuss any possible questions at the QA about that. What I can say is that the taxonomy, I admit it, is not perfect, it's not exhaustive. It's just an attempt to bring some topics together and see a classification of those. Also, an issue is that many challenges of big data are not clear-cut, so different issues might overlap and recur at different levels, so they might affect the individual, but also there can be seen as societal challenges as well. But nevertheless, I do argue, even if it's not perfect, it's not exhaustive, I do argue that this map, this conceptual map, is not of merely theoretical academic value. I didn't do it just to have fun. I think it does have a purpose, and it is, in my view, crucial to be able to reflect on the ways that the big data risks, and properly reflect on the methodologies, on the ways that big data risks can be addressed. So, a point that, a preliminary conclusion that I draw from there is that, and it sounds very commonsensical, is that regulatory approaches to AI cannot be one-size-fits all measures. Instead, what I argue in the paper, based on the taxonomy I have developed in the first part, is that solutions should be searched at the particular level, be that individual or societal, where the problem arises, and they might vary on the specific type of problem. So when you're talking about individual level harms or risks or challenges of AI, what regulatory measures, like those that that bring a harm to individuals, affect individuals, what regulatory measures should we be looking at, those that prevent harm to individuals or safeguard their rights and interests. But when you're talking about societal challenge at societal level, then we should be looking at measures that address the dynamics and types of power that AI bring forward at the society level, not just thinking about individual rights. So that brings me, this is the first part of the paper, and then I go and move on to the main, let's say, research question. That is, what is the role of the GDPR? What role can the GDPR play in addressing AI challenges? And again, all that is developed on the basis and in the light of the taxonomy I developed in the first part of the paper. So first of all, a general point that we all are aware of when you're talking about AI, when you're talking about big data analytics, they're less about really identifying the individuals. They're more about those algorithmic impersonal categorizations of risk, creating risks, opportunities, and the profiles that are predictive, that are preemptive. So in that respect, data, and in fact personal data, has a relational value, does matter, but what matters much more is correlations between the data that will be uncovered and discovered using AI. After this general point, again, the main question, what is the role that GDPR can play in addressing AI challenges? My short answer is limited. And we heard here before that, it develops a it's based on digital constitutional. It's a great idea, but in my view, I'll be much more radical. My answer is a limited role. And a limited role, going back to the taxonomy that I developed in the first part of the paper regarding societal challenges and challenges that relate, individual level challenges as well, but that relate to the outcomes of the processing of personal data. So what is that role? I call it just indirect, instrumental, completely of probabilistic nature. It might be that some AI risks could be indirectly mitigated if the GDPR principles are properly applied. So it has some probabilistic it's probable that it might happen. It has a role to play. It's kind of instrumental but very probabilistic. So what I say, that's not good enough. We are talking about very, very serious issues, very serious challenges. It's not good enough to say we have a measure that potentially might play an instrument in trying to mitigate them. So that's my argument. But then looking at the GDPR itself, and it's not very, it doesn't state that very obviously, but looking at, I have a direct quote here from the Article 29 Working Party. It seems that the GDPR aims itself to a much higher objective than what I argued. So, and I quote here directly the Article 29 Working Party. It says the GDPR aims to address the risks arising from profiling and automated decision-making, notably but not limited to privacy. So this is actually an aim of the GDPR, to address profiling and automated decision-making risks. And then we have we have the specific articles that have been discussed in the previous presentations, or Article 22, with the prohibition for decision-making based on automated decisions, on the automated processing, and Articles 15, and a combination of those articles there that give further rights, so to be informed about the existence of automated decision-making, including profile, receiving meaningful information about the logic involved and contested, and all that. So it's not just that the GDPR assumes for itself a role to address big data challenges. In fact, it does contain certain provisions to do so and all that. And I find that problematic, and I call it in the paper regulatory overreach or normative disconnection. So it seems to me that it attempts to control outcomes of algorithmic processing and grant due process rights to persons that hardly concern the data subject, even if the processing of personal data of a particular data subject is at stake. So, in my view, is that the GDPR is not appropriate at all. It's not just. My argument is not that it's not fit for purpose to deal with AI challenges. For me, it's not an appropriate methodology at all to deal with those. I find it irrelevant to its scope to deal with outputs or to deal with what I call challenges of AI that relate to the outcomes of the processing of personal data or societal level changes. I think it's completely irrelevant to its scope. That's why I find some kind of or regulatory overreach or normative disconnection. But does this mean that it's completely useless in terms of AI and in terms of big data? Not at all. In fact, I do argue that its utility, or it's limited, but it's still important. So it does have a role to play. And going back to my taxonomy that I developed in the first part of the paper, I say that actually the GDPR can deal and can address what I called in my taxonomy and what I classified as individual level challenges that relate to the processing of personal data. Now, obviously, I discussed those in detail in the paper, and I just saw a very quick slide, so you didn't have the chance to see them. What are those challenges and what I classify in that category? But I don't have time to go in detail into that, but what I can say is that they do display some common characteristics. So you can think, I will explain, and you can think of what, and I'm happy to circulate the paper again, of what is included in those challenges that the GDPR in fact can address. So the first is that some of them are what I call actor-related. That means either data subject related or data controller related. So what is an example of those challenges? When data subject related challenges, they're those perceived and alleged difficulties of data subject to take advantage. Okay. So it seems that I'm running out of time. I will leave it there. My main point is, I'll leave this slide because, okay. My main point is that the GDPR can deal with some challenges, AI challenges. Those are what I classify in my taxonomy as individual level challenges relating to the processing of personal data. Again, there are some problems there, but I think they're not unsurmountable. So, to recap, I submit in the paper that we do need to systematize and classify and distinguish the challenges of AI and think very seriously about them when you're trying to think about regulatory approaches and regulatory methodologies to address them. So I do that in the paper, and I say in that respect the GDPR as a legal methodology used can address some challenges, what I call at the individual level challenges that occur, that relate to the processing of personal data, but cannot address another whole set of challenges that I have identified that are at the individual level that relate to the outcomes of the processing and also societal level challenges. And then the question is, how do we go about addressing those types of challenges that I think are completely outside the scope of the GDPR altogether. And there, in the paper, I have to offer only very few preliminary points. So I offer 4 preliminary points. The first is that we always have to, regulatory responses should always correspond to the level and the types of risk at stake. Again, going back to the taxonomy I developed. The second is that those AI challenges might require a combination of different approaches rather than a single legislative measure. And in that respect, I like very much the holistic way that the EDPS is considering, and the holistic approach of the EDPS to consider big data from competition law perspective, consumer law, also data protection, and it might be other ways to do so. Then the third is we might need innovative thinking that might require both a kind of transformation, evolution of things that we already deal with, like discrimination, but how we deal with discrimination in the context of AI. But it might need to adopt completely new rules that are AI specific. And finally, I think that we need sometimes to regulate also the AI stakeholders, the actors, data brokers, platforms, and so on, so we ensure accountability in the society. So I'll leave it there, and I'm happy to receive any questions.
Thank you very much. I would like to open the floor for at least 10 minutes now, and so we have time also to discuss the paper at the end a little bit in a more diagonal form. Who wants to start? Do you hear me? Yes, you hear me. I actually have a question.
Yeah.
I was not here for the previous panel, so probably this discussion has been already lengthy and detailed, but especially based on your, like, if I reverse engineer, and I start with your conclusion, and like this quite strong conclusion that the GDPR is irrelevant to some extent to some forms of processing, or not even, if I didn't understood you.
No, my point is the GDPR and its principles, should be applicable in general in terms of AI in general, but we have to look at the challenges or the harms that AI might produce to consider if it's an appropriate regulatory approach to deal with everything. It's applicable it's applicable because if it falls in its scope of application, it's applicable. But I think so. The general principles, I don't have any problem. I have problem with the particular Article 22 and all those that try to go and regulate AI in different ways through this instrument. That's my issue.
Okay, but then how to say? Because your first disclaimer was like, I will call AI and big data like synonymous. We have already had this discussion.
Yeah, it's not very accurate, but it's.
But like, it's not a critique of your decision to do so, but it's more like the question of to which extent we can, like, because your approach is premised on the idea that not all this kind of processing are synonymous. They are not all the same because they bring to different arms and to different effects on the data subject. So how can, and still we need in law to have a general idea of what we are talking about. We cannot have like a specific regulation for each specific new forms of data processing. So how can we systematize, how can we sharpen GDPR and at the same time resist calling everything AI or big data and so on. So to some extent, how to what can be done in that sense?
I think the GDPR, again, what I think is the GDPR, the general principles, there are the data subject rights, the obligations of controllers should be applicable as soon as something falls within its scope, that is processing of personal data. I understand that also an AI algorithmic decision, AI processing is also processing of personal data. I think the general principles of the GDPR should apply. That's what I say in the paper. What I say is that the GDPR for itself, it assumes another role that which I call regulatory overreach or normative disconnection somehow. It tries with specific articles to go deal with issues that I don't think are even granting due process rights to individuals that are affected by AI. I don't think that is a GDPR issue. I mean, you might want to grant due process rights, but I don't think that's a data protection issue, even if their data were involved and they are actually identifiable. I think it's you might have a measure to grant due process rights for AI, but not through the GDPR. That's what I'm saying.
Okay.
It's not a data subject problem.
Okay.
Okay.
Yeah, no, I found it interesting because if we don't know exactly which kind of processing is happening there, like either we stay with general principles and then we do this kind of every time, I don't know, hermeneutic or epistemic job of understanding how the general principle will apply to that specific case or instance of data processing, which may be completely different the day after, because this is one of these dream, at least, of algorithmic governmentality, as Antoinette will put it. The fact that the algorithms themselves are changing, so what may be grasped today is not what is going to be grasped tomorrow. Because so in that sense, I find it very interesting, your point, and I have this curiosity about how to keep a grasp on the algorithms or on artificial intelligence.
Yeah. Again, I think the general principles should apply, and AI processing is also, in my view, processing that might fall within the protective scope of the GDPR. But then these particular provisions, 22, and all those trying to regulate AI, I think this is not an appropriate methodology to do it a data protection instrument. That's maybe my main point.
Okay, thank you very much.
Can panelists ask, or are we out of time?
Absolutely.
Yeah,
absolutely.
Okay, so thank you again for the interesting topic actually in the presentation. It was hard to follow all the presentation to keep turning around. You went like back and forth with the idea of maybe we need an extension for the GDPR to cover additional aspects, or no, the GDPR is actually more than even what we need. What is the conclusion here? I'm not sure I got the conclusion correctly at the end. Do we need an extension for the GDPR to cover additional aspects, or the GDPR is enough for
now? No, I don't think the GDPR is an appropriate methodology to deal with AI. Okay. I think I deal with data processing, and I accept that if you tell me AI, it might be a case of data processing, and I say, yes, it should be applicable, but it should be applicable through its general principles and data subject rights, rather than try to create new types of regulation within it, that it does to an extent.
Thank you. Yeah, this will trigger additional discussion, but maybe we can do it offline afterwards.
I'm pretty sure. And now for something completely different, but actually very much in line, I think, in our conversation. Let me introduce Gianclaudio Malgieri. Gianclaudio is an attorney at law and a doctoral researcher at LSTS at the Free University of Brussels, where he is task leader of the EU Panel Fit project. His research focuses on the unfair imbalance between data controllers and newly vulnerable individuals in the automated decision-making environment. He is training coordinator of the Brussels Privacy Hub and lecturer of data protection law and IPRs at VUB, University of Pisa, and Sant'Anna School of Advanced Studies, where he got JD and LLM with honors. He has published more than 25 articles in leading international law reviews, including the Italian handbook of data protection. I was very impressed, and I should be. Please.
Okay, so thank you very much. I'm very happy to have an Italian moderator that can well pronounce my name and my surname. It's like an emotion for me. So I'm happy also to follow up to the previous presentation, because I think we slightly disagree on several things, and I learned that the most interesting thing of academia is disagreeing. So I wanted to ask you a question, but I didn't want, I think it's better to present first and then we discuss maybe. because I think that GDPR is actually one of the best tools we have. Maybe I have this empirical, this practical approach, pragmatical approach. So this paper has been co-authored with a proper senior one, who is Margot Kaminski. She cannot be here because from Colorado to here it's 12 hours of travel, and sometimes it's not so easy for 15 minutes presentation. But so basically, we wrote this paper about algorithmic impact assessment, and so to add a new layer of complexity to automated decision-making discussion, we will talk about data protection impact assessment as a tool for regulating also automated decision-making. And then we propose this multi-layered explanation thing. So basically, the paper is already on SSRN with a slightly different title. And at the same time, it will be presented in 5 days in a FAT conference in Barcelona with another different title. So basically, it's a bit a mess, but I hope you can follow up. So the first, the premise where we move from is that the GDPR is a binary tool. This is a notion that Margot, as an outsider, because she's an American lawyer, she's an American scholar, tried to look at the GDPR. No? So it's both granting individual rights, and at the same time, it's a co-governance tool. Because it's a tool, I have one slide for co-governance. So accountability principle in Article 5 is basically an inspiring principle for the whole system, and it's based on the idea that data controllers can co-determine the means, the safeguards to be compliant and to enhance data protection. This is a form of delegation to private, but of course the public will have to check. And so the dialogue between DPAs, data protection authorities, and individuals, controllers or companies. Also, the risk-based approach is very much based on it's the real core of accountability principle. The higher the risk, the higher the safeguards. And data protection impact assessment, to which I will dedicate a couple of slides, is also something that is somehow viewed as a privatization of data protection somehow. So we delegate to data controllers to check their own impact and risks of their data protection, of course, just in high-risk data processing. On the other hand, we have rights, and since we are talking about automated decision-making, I will just, of course, mention the 3 articles or 3 or 4 provisions that I think so far have been reminded several times. So we have, from one point of view, information about logics of the algorithm, which is the general information. 13 and 14 is an ex ante, and 15 as a right to access. I will not repeat myself. 22, paragraph 3, we have, of course, contestation. We have right to express our own view and to have a new decision with human involvement. And recital 71, which is just a recital, a poor recital, but so, triggering so big discussion, incredible big, about explanation. So, and then we have member states implementing Article 22, paragraph 2. Because in paragraph 2, member states, according to that, member states, letter B, can provide new cases with new safeguards in which automated decision-making is allowed. So just to quote a song that I'm very, in this moment it's always in my mind, your mess is mine. So the mess of GDPR about automated decision-making is our mess in terms of scholars. Let's try to look at the problems of explanation first, and then I would like to propose some solutions sometime, because I think that the time for discussion is over, and now it's maybe time for some solution. And it's also a bit difficult to imagine a new regulation or a new law. There is the von der Leyen promise of AI regulation, but still would not be about data protection, probably. So let's try to profit from the existing law. So there is some problems in explanation. I've been a great fan of right to explanation, etc. But there are a couple of problems. First of all, there is no legal consensus on explanation. It's a recital, it's limited, as we were saying, 22 has some restraints, etc. Second, it's not always technically feasible. So we have seen Google has developed this new tool. Yesterday there was a conference also about that. So the what if tool, the counterfactual explanation through algorithms, etc. But how you can really put these two words in communication. The words of computer science and the words of humans that have linear narrative, okay? The third problem is transparency fallacy. So even if there was a consensus on explanation, and even if it was technically feasible to explain algorithm, still it's fallacious what we have, because transparency, information duties are generally ignored by consumers. Consumers are generally irrational, following behavioral law and economics. Data subject, not consumer, but behavioral law and economics is about consumers. And also, explanation is maybe not our legal goal. What we want is a justification. We want that an algorithm can be contested because it lacks fairness, because it's discriminatory, because it's manipulative, etc. In order to do that, so first we propose this multi-layered explanation. So we imagine, first of all, 3 layers of explanation, and then we combine these. This is just, a first attempt to a systemic effort in the GDPR to do that, connected to the data protection impact assessment discourse. So why we imagine 3 layers of explanation? First, first of all, because there is this different views. Article 15 is about general information, and 22, related to recital 71, is about more specific explanation of the single decision reached, which is different from the logic. It's just explaining the single decision. Then Article 29 Working Party, in opinion of October 2017, seems to suggest that more layers of explanation are needed. And also, we have the risk-based approach, saying that the higher is risk, the higher should be the safeguards. So if your automated decision-making system is producing more risk, probably you should look at more safeguards. And if the data controller needs to select more safeguards, he cannot ignore explanation. It's in a recital, we know, but still, having more duty to have better safeguards, this is something that he should consider, apart from bigger creativity about that. So, which are these 3 layers? The general information layer, so Article 15, meaningful information about logic involved, and this is something on which Article 29 Working Party has developed a questionnaire that we will see in a minute. Then the group-based information. What is this group-based information? We were struggling a lot about this notion of group-based information. It's an intermediate level between general and individual explanation, and since in our view, it's justified by right to contestation, because Article 29 Working Party has often explained that the right to contest needs to be enabled by some meaningful information, which is maybe more detailed than a general information at Article 15. It's based on the relevant factors that your group, which is of course a transient group, which is of course a dynamic group, triggers in the algorithm at that moment. And then the individual explanation, which is just explaining why at a certain moment you received a certain decision about you. Now, of course, it depends on the risk, as I was saying. The higher is the risk for data controller, the higher should be, this is the general level, but if the risk goes on, the data controller might be required to give individual explanation, of course. So, now let's look at data protection impact assessment. Why we want to keep in the discussion the data protection impact assessment? Because exactly as Maria was saying before, 22 is limited. We need something more. We need a bigger view on risk, okay? And we have it, not only, in my view, not only Article 1, Paragraph 2 refers to the GDPR as the protector of, in general, fundamental rights and freedoms, in particular data protection, but also data protection impact assessment is an analysis of risk of high risk for fundamental rights and freedom for individual. I give for granted how DPIA work. We are all more or less GDPR guy here, and I have just 15 minutes. But just to look at Article 35, paragraph 7, explaining how a DPIA should be like, we compared these to the guidelines of Article 29 Working Party about explanation and information. So basically, what we were seeing is that, in the DPIA you need to do a description of the processing, which is very similar to a general information, systematic, which is very similar to a description of the algorithm, of course, and so also to the logic involved. There is a clear overlap, or at least a partial overlap of these two. Then we have an assessment of necessity and proportionality. There has been a lot of discussion about this, what necessity and proportionality means in Article 35. But basically, if we compare these to the algorithm transparency guidelines, there is the request of explaining why you use some categories of data and why your profile building is relevant, why the algorithm is using exactly those data. In our view, this is a form of necessity and proportionality assessment. So, and this was something that we wanted to emphasize. Then, of course, you have to assess the risk to the rights and freedoms. And it's also something that you need to analyze according to the algorithmic transparency tools. In particular, you have to propose some measures, which is the measures for mitigating risk, but at the same time, also, Article 22.3 requests some measures to implement automated decision making. So just how it should work in practice, the joint application of algorithmic DPIA and explanation right. We describe the processing, and this is a way of explaining the algorithm. Then we assess the risk of the algorithm, because what we care about is not just that the algorithm is explainable, but that the algorithm has an impact on individuals and on collective level that is not unfair. So basically we assess the risk. Then through Article 22.3, we collect inputs from individual, right to contestation, right to have a new decision, human involvement, etc. And for example, the UK system is very advanced on that because they have an accountability system for contestation, but I will not deep into that. So we assess the risk, we collect individual rights, reaction, and this might be a feedback. And then we redesign the processing because the DPIA requires a cyclic, continuous system. So, of course, we know that the DPIA has some problems. First of all, the summaries should not be public. So how it can be an explanation if it's not public? It can be a private report, yes, but Article 29 Working Party suggested to make summaries public, at least as a best practice. Then, also explaining the algorithm and assessing the risk. Actually, that arrow is also in the other direction, because if we assess the risk, we should also explain the risk to the user. And this is something that justifies the algorithm. And also, allowing contestation, etc., is already a risk mitigation measure. And this is something that goes toward algorithm justification. So just to summarize 2 slides about the benefits of this approach, which is just a first step approach. So first of all, it's an optimization of compliance efforts. Data controllers need to do both, needs to be compliant both with Article 22 and with Article 35. Doing this together will help to improve the system and will optimize their efforts. Then, second point, I was already saying that publicly disclosing parts of the DPIA is a best practice. So it's also a form of privacy by design, because remember that privacy by design is not just technological measure, it's also organizational measure, and this is an organizational measure. Then third point, disclosing information to individuals about the algorithm and collecting subject reaction might be a way to be compliant with Article 35, Paragraph 9, about collecting the view of data subjects. I know that this is very limited after the lobbying that there was in the discussion of at the European Parliament, because now Article 35(9) says where possible we should look for the view of the data subject, but still data controller need to do that. And the last point, if we really manage to do this systemic and joint application of DPIA and explanation at the same time, this might be a way to overcome the transparency fallacy, because it's not just to give the individual a narrative about the algorithm. It's in reverting the burden of proof about unfairness. I say, this algorithm is not unfair because I did the analysis of risk and I mitigated this way. And I'm explaining you not just that, the algorithm, but also the legal justification of it. So, thank you very much. I think I'm out of time. Just some more biblios, or better, some background of our work. So, some paper that Margot and I brought about this topic that can really, I think, be a premise for that. And I will be happy to hear your questions. Thank you.
Thank you very much. The floor is yours. I already see 2 questions. Please.
Do you hear me? Yeah. Just last question to you.
A little bit more powerful.
Okay, thank you, Gianclaudio. I hope I pronounce it well. Gianclaudio Malgieri.
No, but because you speak Italian.
Oh, that's it's easier then. So, but maybe it's a question for all of you. I mean, usually when we talk about accountability of algorithms and the need to know and so on, we usually put them all in the same level. It looks like, I mean, rules should be applicable to all kind of algorithms in every part of our life. I think that we are making a mistake in this. I don't think that we need to know the same if we don't use the algorithm for the same things. And I will put you an example. Imagine that you are using an algorithm for medical diagnosis, okay? To go to a doctor. The doctor will be the one who's taking care of you, but the doctor might have an algorithm there that is supposed to be helping him, okay? So the point is that if it works well, the algorithm will probably, just to try to provide some feedback and say, you might have this disease. Mm-hmm. Well, a common physician, they always have the same problem. They don't have a lot of time, and always happens the same. If they manage to get into the mind what could be a right diagnosis, usually they take it. The thing that happens is that sometimes they miss it. Mm-hmm. So if they have a machine there that is telling that it could be this, a physician would say, yes, of course, I didn't think about that. And they would say, yes, this is what we have. I don't think that the patient should need a lot of things, about how this works. Not even the physician, because it's not needed really. They need another thing. It's totally different that, for example, when you are using this algorithm to make a decision on whether a dangerous offender must go in jail or could go out of jail. It's totally different. So I think that maybe the measures, sometimes we get too crazy with some of them. It looks like we are always getting to the worst. And I think that sometimes it's much easier than it seems. Just a comment, but might be fair. I don't know. Yep, thank you.
Thank you very much. If you don't mind, we will take also the second question and then... Please.
Thank you very much for the speech. It was enlightening. I just had a slight question of precision. When you give the 3 levels of explanation, I do not really perceive the distinction between the second and the third cases. What concrete situations do you aim with both, and how do you switch from one to the other in cases where explanations might be required? Also, from the guidance of the Article 29 Working Party, I do not see where such a distinction appears. So if you could specify it, thank you.
Thank you very much. Let's start for you.
Okay,
first.
so basically, so to Inigo question or comment, I think it's very relevant because basically, I think that algorithm accountability should be on a context-based analysis. it's so clear that different AI systems have very different harms and risks. For example, facial recognition has some problem with security and discrimination and stigmatization, while newsfeed can have problem of manipulation. Okay, so I think that even just in the high-tech world, this is a story. And then if we look at different sectors like health, insurance, etc., it's even clearer. So I think that member states were the only ones to maybe understand a bit this. Some member states doing an implementation of Article 22 on a sector-specific basis. We have Germany, who has implemented just in insurance. We have Poland that has implemented just in welfare. We have Netherlands that has mostly implemented in public sector decision-making. Then in France, we have all the problems with education decision-making, the university, etc. So we have, and I think that the context-based relation is very interesting. What I think also is that DPIA is such a flexible tool that can be used for everything. It's written in a general way, and this is the strength and the weakness of DPIA, in my view. We don't know what risk to a right means. I loved to read papers from Niels van Dijk, from Darius Kloza, from Darek, from Katerina de Mezzo. They all write about this, but still we need to know what risk to right means, and I think this might be the scalable way to do that. To reply to the second question, so the three-level explanation, what is the difference between 2 and 3? Basically, and this idea, so this paper should be developed in a paper in collaboration with some computer scientists to give us more view on how the differentiation between level is possible, advisable, and adequate. The idea is that we have general information, we have individual explanation, but there might be a less granular level that could make understand what type of algorithm has been developed for some particular scenarios. So it's an intermediate form, doesn't give, not giving the specific explanation of the specific decision, but it's like for people in similar situation to yours, this is what happened. I know that the definition of situation is very difficult and broad, but still, in our view, this was an intermediate level that would avoid the difficulty of the third level, which is individual explanation, but still would be something more and added value to general information. But of course, this is a weak point on which we have to work more. Thank you.
Thank you very much, Gianclaudio. I suggest we move to the third speaker, Al-Momani. Alaya is a researcher and a PhD candidate at the Institute of Distributed Systems in Ulm University, Germany. His research interests include topics in privacy, data protection, and machine learning. He enjoys addressing the intersection among the previous topics in use cases related to automotive systems. Yeah. Thank you very much. The floor is yours.
So, thank you very much. Respected committee of the panel and dear audience, thank you for keeping this session very interesting. As over the last few years, we actually encountered a huge development in the data protection, and we think it's time now to compare them together, and we look into this from a technical perspective for automotive systems. In the last speaker just suggested that probably you need maybe computer scientists to work on some papers. We are some computer scientists actually. I come from Ulm University, the Institute of Distributed Systems, and this work is together with Frank Kargl and Christoph Bösch. So we are actually witnessing nowadays a huge and historical development of data protection regulations. I came across this article last week, actually, and the title is kind of catchy. I liked it. It is actually raining privacy bills, and I couldn't agree anymore, to be honest. And we all know that it's not only in the United States, it's actually all over the globe. We are encountering this huge development and historical development. Consumers and end users are respecting this and appreciating this development because they can practice one of the fundamental rights, which is privacy, obviously. On the other hand, the automotive industry, we look into these from the automotive industry perspective. Why automotive industry? Over the years, automotive industry has transformed actually from being just like an industry that introduces vehicle that only drives to industry that collects vast amount of personal data and personal information. Nowadays, vehicles actually are equipped with state-of-the-art tools and technologies for example, perception. This may include communication, vehicle-to-vehicle communication or vehicle-to-infrastructure communication. This may include state-of-the-art sensors, LiDAR sensors or so, for enabling autonomous driving. The goal of all this development, to put it simply, is to have a better driving experience in general. This includes maybe infotainment services to the driver or to the passengers, or routing services, for example. So we all know that instead of looking for a parking lot, if your car tells you where is the nearest parking lot to you, it saves you a lot of time. However, this collects a lot of amount of personal information, personal data. Among all these services that the automotive industry offers, there is one service actually that kind of impacted the way we live in the last few years, which is ride-hailing services. I assume everybody is familiar with it, and over the years there has appeared many service providers offering such a service. In 2019, according to Statista, the number of users for these ride-hailing services is almost 1 billion users around the world, and the total revenue for this industry is 180 billion, and this is a lot of money. The trend now in these ride-hailing services actually is going toward utilizing autonomous driving to offer driverless taxi cabs services. This is like Uber, for example, is working on something like this. In Japan, actually, they already started doing some field tests for that. And in the United States, in Texas, some startup, they already actually started their driverless cab for some commercial purposes. But to understand why this is of particular interest from a data protection perspective, let's actually look into the system model and try to understand what is going on here. Often you have a consumer and a service provider. The service provider collects some information from the consumer. This may include the geolocation data, a pickup and a drop-off point, often along with the desired time of the pickup and the drop-off. And this also may include some identification. Biometric could be facial recognition, ID, for example, or fingerprint. Why is that? Because nowadays, actually, how it works that when you want to enter the vehicle, when it arrives to you, there is a driver in the vehicle, and you can confirm your identity with the driver. But when it's autonomous, when the vehicle is autonomous, there is no driver. There is no human factor in this case. So you have to provide some kind of identification. The service provider forwards this information to the vehicle, to the autonomous vehicle. The vehicle drives to the passenger to deliver the service. Throughout the service, the passenger, the consumer, actually may request some infotainment services. Could be music or video streaming, depends on the length of the journey, and could provide also some navigation services, for example, to navigate around the restaurants close to the drop-off point. And furthermore, also, the service provider may want to record actually what is happening in the vehicle, to monitor the health of the passenger. And this is especially interesting in the case of carpooling, because we don't have a driver anymore. And in case of a crime, for example, or something, there might be some evidence or so. In short, to put it, to summarize here, is that the service provider actually obtains a lot of information, personal information about the consumer. In this case, this may be used to process even and infer further sensitive information about the consumer as well, and also may be shared with third parties. Some of the services may actually be processed from at the third party also. What is even more interesting is that such a service is often offered in a worldwide setting. It is not a regional service, it's a worldwide service. And this brings the challenge to such service providers that they have actually to comply with several data protection regulations at one time. For example, there are many data protection regulations around the world. I will just talk about them in a second. But the challenge here is that, is it possible to build a system that is likely compliant with several data protection at a time or not? And if so, what are the main aspects to be considered to do this? To answer this question, we look into some among the major automotive markets. In particular, we look into the European GDPR, of course, and we look into the United States, and we pick the California CCPA as one of the newest and hottest privacy acts there. And we look into the Japanese APPI, and we compare them together to figure out whether it is possible to build a system considering these regulations or not. Okay. First, let's talk about the similar aspects of these on a very high level, of course. Most of them actually, or not most of them actually, all of them, they share the idea that the territorial scope where they apply it goes beyond the physical territorial scope where they have been introduced in. So a company operates in Japan with the APPI. It may also need to comply with CCPA or GDPR as well. In general, these regulations, the three regimes, offer wide range of rights to the consumers. For example, the right to be forgotten, it's offered in the three regimes. The right to access information, the right to be informed about the processing happening on the data. The three regimes somewhat share tough sanctions. What's interesting to mention here is that the APPI, the Japanese APPI, actually foresees imprisonment in some cases, in severe cases. GDPR and CCPA have higher financial penalties. The three regimes define a very strong and broad definition of personal information. For example, the three regimes consider biometric information clearly as personal information. And the three regimes as well requires processing or keep records of processing of the data. These are among the similar aspects. There are some few others, but these are like the highlights, let's say. And about the differences. There are a few differences actually in these regimes. For example, the GDPR foresees the appointment of a data protection officer, while the other two, they don't. I actually don't know what is this triangle here, but probably because of it's not my machine, so yeah, I don't know what. Yeah, okay. So for geolocation data, almost all of them consider geolocation data as a personal information clearly, except the APPI, it considers movement data, which is technically not geolocation data because movement data is like a trace of locations. So this might be like a loophole or something to play around with things. Purpose limitation, the CCPA does not foresee or impose any limits on the purpose, at least clearly on the purpose of the processing of the data. And the CCPA actually offers only opt-out option for selling of the information, not for the process, not a general opt-out option, while in the GDPR and APPI, it is clearly stated the opt-out option. The GDPR and APPI, they both foresee transfer adequacy when it comes to data protection adequacy when it comes to transfer, international transfer, overseas transfer. This is not stated in the CCPA. However, the CCPA clearly stated that you shouldn't, there must be a clear link for the user to opt out from the selling. But it doesn't matter whether it's international or national selling or transferring of data. Just minor, the GDPR and APPI, they foresee special category of personal information. The CCPA don't. Health data is not considered, is actually out of scope of the CCPA because it falls under different data protection regulation, different privacy act, which is the Health Information Privacy Act, the HIPAA. Breach notification, the GDPR imposes a limit of 72 hours for the breach notification. This is not foreseen in the APPI and the CCPA. However, what's maybe worth mentioning here is that in California, in the United States, they take into account the sectoral environment in the states, and it's the breach notification is more like sector dependent, depends on what kind of use case you have, sector dependent. Data portability is not foreseen in the APPI, so actually a person cannot like download a version of the data the service provider has. And the right to non-discrimination is not clearly stated in the GDPR as well, but of course we know that in the Charter of Fundamental Rights of the EU, it is actually clearly stated. So, okay. It may look like the CCPA lags behind the other two just by looking, but to be honest, some of these X's are just minor, but there is one particular point which makes the CCPA really maybe falling behind the other two, which is purpose limitation and not imposing data protection principles like the GDPR and the APPI, at least clearly. But we figured out after all this comparison that it is actually still possible to build a system that is, after considering the three regimes, these ones, because there isn't a contradicting requirements between each. So you just simply have to pick the best of each word. And just as an example, a service considering these three regimes would look something similar to this. You have the consumers and you have the service provider. The service provider collects clear pieces of data, whether personal data or not, for clear purpose, and store them for also to be processed later in clearly, and store them in an anonymized fashion when possible, of course. However, we all know that geolocation data, anonymizing geolocation data is somewhat tricky, let's call it like that. Each of the single data items stored, it should be processed, should be stored for a clear process purpose, and the process purpose should be checked whether it's lawful or whether it needs a consent or not. It's legitimate without a consent. And in case of change of the purpose, the consumer should be informed about that, of course, and accordingly the consumer should be able to actually withdraw the consent, opt out, and access the data whenever needed. The consumer should also have the ability to download a version of the data stored at the service provider and delete the data whenever wanted. Now, all these rights, they require actually privacy-trained staff along with a data protection officer, and both they kind of contribute to and benefit from an enhanced privacy awareness in the system. The service provider may also outsource some of the processing to a third party. In this case, it's clear who's the data controller and the data processor, and the third party should process with some binding contracts, should have some clear purpose of the processing, and again check if the... Yes?
I received myself an injunction that we have to close in 10 minutes, so...
I can
ask you to close in 2, so that we have at least time to launch the questions, and for those that want to stay with us a few further minutes, we can continue the conversation.
Yeah.
Thank you.
Okay. So, yeah, you may actually, okay. There must be records kept for processing and transferring at will at both sides, and in case of transferring the data, whether it's overseas or not, the don't sell my data link should be checked if it's checked if it's not selected by the consumer. Transfer adequacy should be checked as well, and clear data retention approach should be also enforced, as well as breach notification within 72 hours. So what we considered only is only 3 regulations, but in practice there are much more. I mean, in the auto aliens in the United States, there is the new the Consumer Privacy Protection Principles, there's the new Washington Privacy Act, and there's the New York Privacy Act, and many, many more. And this makes the challenge even harder and harder on service provider to comply with all these regulations. But to make it easier, there's one way to make it easier is that the essence, I mean, the main point of all these regulations is respecting consumer privacy. So for a service provider, if you want to comply with several data protection at one time, you're likely to build a system that respects your consumer's privacy truthfully, then you are likely compliant, or at least you wouldn't face huge and major changes due to some regulations. For the future work of this direct comparing additional regulations, which may include data protection or non-data protection regulation, to figure out if there are some interference between them or contradiction between them, and consider additional service, either automotive or non-automotive services. Yeah, ladies and gentlemen, thank you very much. Yeah, I would be happy to hear your questions.
Thank you very much, Laya. Some question from the floor. Okay, then I have a question for you.
Sure.
You were saying that you had a different perspective on the conversation that we started at the beginning about GDPR and artificial intelligence. I think the public is way more law-oriented than your own background. So
Yeah.
how would you explain then your position based on your research on this conversation?
From the AI
Yeah.
perspective? So that's a very good question, actually. Thank you. Thank you very much for that. The way you see AI, it depends, again, this all depends on the use case. We're talking about just general. Mostly if you consider AI as a processing, then the points we mentioned in the presentation applies in this case, but I don't know whether you see AI as a different tool other than only processing of information, then we may need actually some extension for GDPR. Yeah. I'm not sure whether this answers your question.
Because I think that, don't get me wrong, but like your kind of research is the object of desire for many in this room and around CPDP, like finally somebody that knows how things works really, but it's difficult to follow, obviously, because we live in a different planet, so to say. So maybe a best question would be, how would you consider you a use case? Like, what's your worldview? What's your perspective compared to the other
So the point is that it is the question we try to answer here is that whether it's possible to build from a technical perspective. Again, we're not like lawyers. We didn't investigate the law deeply, let's say. But from a technical perspective, we were worried if there are like some contradicting requirements between the regulations, at least the data protection regulations themselves. It turned out there isn't. And it is possible to build such a system from a technical perspective only without putting, again, as I showed here, just some organizational measure. And so without putting a lot of like security measures, let's say technical measures in there, it is still possible to build a system considering the regulations. But what might be or become interfere with this is other regulations other than data protection regulations, like for example, state security regulations or something that requires you to collect this information or so. This may interfere with this, and from a technical perspective, this where it becomes more challenging because you, on the one hand, you want accountability for the system. You want, for example, to monitor or collect data as much as possible. On the other hand, you want to protect privacy of the people. And from a technical perspective, this becomes more challenging, where to draw the line, let's say, and how to achieve technically how to achieve such both requirements at the same time. This is very challenging, and I don't think if anybody has an idea how to do that easily, I would be happy to hear it. Yeah. From a technical perspective as well, because we're talking here a lot about data protection only, such a system like what I presented to you here. This is not, of course, this is not privacy, this is not regulation compliant. No, I don't. This is by all means, it's not regulation compliant. This depends on the specific use case, of course, what kind of like processing you want to do and so on. But from a privacy perspective, from a technical privacy perspective, as a privacy researcher, for example, this is not privacy friendly, because once you give your data, even if you're okay with that, once you give your data to the service provider, for example, geolocation data, your privacy is compromised because you cannot trust the service provider 100%. There is always like some internal threat. We all know that. So from privacy perspective, this is not privacy friendly. How to make it privacy friendly is to offer the service while, for example, the data is hidden. Is it possible to do that from a technical perspective? There are some privacy enhancing technologies. I'm sure some of the audience are aware of them. For some services, it is possible. For this particular service, it is challenging. I have published some articles before. I can refer you to them if you're interested. It is quite challenging because at the end, you want to benefit from the service and you want to reveal your geolocation data to the service provider. Yeah.
Thank you very much. Any last comment from the panel? Okay, I can only ask you to thank with me the panelists and for their presentation, their papers. I'm very much looking forward to read the next version and possibly the published version of these papers. And thank you very much again for being with us.